19 months after the Supreme Court ruled that Nigeria's 774 local governments must receive allocations directly from the Federation account, compliance remains uneven. The July 2024 judgment struck down the state-local government joint account, raising hopes for grassroots governance. Yet, across most states, governors continue to dominate council finances, citing constitutional ambiguities. Now, Section 7 of the 1999 Constitution guarantees elected councils to also empower states to legislate on their structure and finance, creating contradictions that allow governors to dissolve councils and retain control of funds. In practice, allocations in states such as Imo, Kwara, Lagos, and Cross River are still routed through joint accounts, while many councils have yet to open the required accounts with the CBN that's the Central Bank of Nigeria. Even where governors claim compliance, independent verification is scarce, leaving councils financially dependent. Well, tonight we unpack the Supreme Court verdict and also constitutional gaps, and whether Nigeria's third tier of government can achieve genuine autonomy or remain subject to state control despite the ruling. Joining me to discuss this, of course, is Bengba Yotiom, is a former Publicity Secretary of the People's Democratic Party, Benue State. He joins from our Abuja studio. It's great to have you again, Mr. Yotiom. Thank you for your time.
You're welcome. It's always a pleasure being here.
All right. I know we started this conversation a while back, but we couldn't, conclude because of time constraints. It's great that we can continue it now. As of now, many states, if not virtually majority of the states, still have their allocations, that's local government allocations, still going through the state governments, even though there's an existing Supreme Court ruling in that regard. And Mr. President has been emphatic on this issue that local government autonomy should be allowed to happen. Looking at everything that is happening, what do you, aside the issues that have been highlighted, consider as bottleneck?
Yes. Thank you for having me back on this program, because the last time, like you said, that I was here, time constraints couldn't allow us to do justice to this very serious topic. Now, going straight to what I see as the constraints to the implementation of the ruling of the Supreme Court, I think that what Mr. President needs to do, because the onus is on his table right now, the way I see it, is for him to go ahead and implement the aspect of the July 2024 ruling of the Supreme Court, which highlighted and provided that, firstly, local governments should have funds meant for them sent directly to their accounts. That local governments should also have full autonomy over their finances, and that constitutionally local governments should operate as a tier of government that has autonomy and that is recognized by law. And then the implementation, that was a declaratory judgment. That, in law, you look at that as a declaratory judgment. The court had gone ahead to mandate the federal government to withhold funds, that's allocations to states, which fail to comply with that ruling. There's no gainsaying the fact now that everyone in this country is tired with states controlling local government funds, because whereas the Constitution had provided for state control or state participation in the allocation and the disbursement and application of funds meant for the local governments, I think that what that provision intended was not what we have presently. Local government, control of local government funds was introduced in the Constitution of Nigeria first in 1979. Now, by 1989, when Ibrahim Babangida was a military president, he abolished the joint, what you have as the Joint Account Allocations Committee, that's the JAC. Now, he abolished it between 1989 and 1993, when Babangida exited from power. I can use a practical example of my own state in Benue. The quantum of development, practical physical development that we had in the local government areas, executed by local government councils between 1979 and 1993, no, 1989 and 1993, is much more than the physical development you have in Benue State from 1976, when the state was created, up to date. If you remove those 4 years between 1989 and 1993, what you had on ground in terms of physical development surpasses what you've had from 1976 to this present times we're talking about, 2026. Why is it so? Between 1989 and 1993, there was no state government control of local government funds. Funds meant for local government councils were sent directly to their accounts. Local government administrations had the leeway, they had the freedom to apply those funds. They executed very serious projects in terms of rural feeder roads, in terms of community health clinics, in terms of primary schools, several other aspects.
But there's also the issue, please hold on.
Now, this tells you that when local government councils are allowed to control and apply their funds directly, definitely there's going to be development.
Okay, but there's also the issue of accountability, because I remember also when we had this conversation earlier, we had the Commissioner for Local Government and Chieftaincy Affairs, Kano State, as guest. He was actually meant to join us this evening also to continue this conversation. Hopefully he will join us in the course of the program. But one thing he said is that he also made reference to accountability and said sometimes local governments might need to be, and this is me using the word loosely anyway, controlled to ensure that they use the money sent to them for what it's actually meant to be. So I'd like you to speak on the issue of accountability, which is also an issue of concern. That right now we would see a situation whereby local governments have more monies in their coffers, but how do we ensure that it's used for the development of the community and not personal, priorities?
When any functionary of government, when any functionary of a state government canvasses that sort of view, it represents what you may call in law a mischief. Yeah, you're trying to introduce a mischief content into a law, an existing law. Let's take a step back and look at what we have by way of a governmental structure in this country. We are running a three-tiered federation. You have the federal government. It has its own jurisdiction. It controls funds meant for the administration of government within that tier by itself, with checks and balances which are embedded in the law. You're supervising such operations of government within that tier. Now you come down, you have the second tier, which is the state government. The federal government does not control the state government in the manner that the state government wants to control the local government, because the state government also has provisions for accountability embedded within the structure of the state government. You have a legislature which oversights the operations of the state government. So the federal government is not per se controlling the operations of the state government in the manner of a little child who needs to be checked. When you go down to the local government tier as well, they have the legislature, which is vested with the constitutional mandate to oversight the application of funds meant for the development of the local government areas, as well as the administration of the day-to-day running of the local government. You do not need the state government to come in the manner of a head boy to control what the local government administrations are doing at that level. The intendment for the creation of the JAC was not what we have now. And like I said, when I said earlier that you have what you may call the mischief content in what is happening right now, what it simply means is that the state governments have turned the law which allows them participation in the administration of funds meant for the local government councils into something that was not intended when the law creating JAC was being framed. And of course, there's what you call the mischief rule in law. What does the mischief rule say? In the what you call the Haydon's case of 1584, Lord Coke had made it clear that in every codified law, there exists the potential for mischief. There exists the potential that someone or a group might turn around and use that law against the intendment of the framers of that law. And so where this happens, the courts have the leeway to interpret, to make pronouncements in a manner that cures that mischief, that takes care of what you have by way of subversion of that law. What we have now clearly is the state government subverting the intendment of the creation of the JAC, and that is what they are holding on to now. But the pronouncement of the Supreme Court on July 11, 2024 has effectively put paid to that. So the state governments don't need to control local governments in the manner that they have their little children, in the same way that the federal government don't come down controlling them. There are checks and balances created by law for the federal government to run its own affairs, for the state government to run their own affairs, for the local governments to run their own affairs. So the issue of accountability is embedded. The law is copiously adequate on that.
All right, thank you very much.
The state governments don't need to come down controlling the federal, the local governments.
All right, we'll go on our final break. Once we return, I'll be taking your final remarks on this matter and what maybe you recommend should happen to expedite the autonomy going forward. Stay with us, we'll be right back. I still have Bemba Iotiom. He's a former publicity secretary of the People's Democratic Party, Benue State, as my guest this evening. He is, of course, joining us from our Abuja studio. Thank you for staying with me. Now, before we go and wrap up this evening, what do you recommend? And I would like you to please put this within 60 seconds or 30 seconds thereout. What do you recommend can be done to ensure that state governments comply to this court ruling as soon as possible?
The ball, like I have said earlier, is in the court of Mr. President. The insistence by Mr. President that state governments should comply with the ruling of the Supreme Court by granting full financial autonomy to the local government councils is the most pro-people's move that President Bola Ahmed Tinubu had made. And so when I had appeared on this program the first time, I had made it clear that it is one policy, it is one move that requires bipartisan support to Mr. President. He should summon the political will to put his foot down on that aspect of the declaratory judgment by the Supreme Court, which empowers him to withhold the allocations meant for those states which failed to comply with the ruling of the Supreme Court. It's very clear. It's clear. The court, the pronouncement of the court is law. But I know that there are a few persons who have argued
because
that.
we need to go.
You still have Jack.
Because we need to go. In one word, some watching this would say that that appears to be a tall, will I call it recommendation, withholding the, of course, allocation of states that fail to comply, given the fact that many of these governors are also defecting. Do you see that happening? In one word, please.
That's why I say political will. Political will. If Mr. President summons the requisite political will, he can implement this. The declaration of the Supreme Court is law. It supersedes whatever the governors might be saying is provided in the in the Constitution by way of the Section 162, which allows them to have joint account allocation committees. The Supreme Court has interpreted, and that pronouncement supersedes that particular provision because it cures it. Whatever exists within that provision as a mischief has been cured by that pronouncement of the Supreme Court. What is left to be done now is the political will by Mr. President. All
right, thank you so much. Benwa Iotiom is the former publicity secretary of the People's Democratic Party, Benue State. Of course, speaking to us live from our Abuja studio. Once again, thank you for your time, sir.